524-005-524 CB.
Appearances, please.
Good morning, Your Honor. James Pierce appearing on behalf of the Cincinnati Corporation.
Mr. Pierce, good morning.
Good morning.
Good morning, Your Honor. Eric Minch on behalf of A123 Systems LLC.
Why are you two always first every week? And
Because
you're every week now too. You guys are getting to be frequent flyers, man. I'm taking notice.
I'm not
We're almost
happy
done.
about it, Judge. But we're
Yeah.
here, we're ready,
Neither
we're
am I.
punctual, we're on time.
All right. Yeah, driving me nuts with discovery disputes. Anyway, what's up today? Motion to compel another one? Didn't we just have one last week and the week before? And
We did, Your Honor. So this is a motion to compel 3 separate discovery requests, 1 interrogatory and 2 requests for production. I'm happy to present my motion now or take any questions. And I'll be brief.
I've read it. You guys got a vibe going here with this case, but go ahead, Mr. Pierce, make your record.
Thank you, Your Honor. So we've served 2 requests for production and 1 interrogatory that are at issue in this motion to compel. I'll start with the interrogatories. There's 3 interrogatories at issue in our 3rd set. They didn't answer any of them, A123 that is. They objected to all of them as being untimely and that we have served too many. The timeliness argument, we served these on May 2nd. They have 28 days under the court rules to answer. That means the last day to answer, the response is due on May 30th. Last day of discovery was May 30th. I don't understand how a timeliness objection is proper in this case. They said we served 2.
So you served them before the end of discovery?
I served them before the end of discovery and with enough time for them to submit answers within the discovery deadline.
I'm waiting suspensefully as to why they're untimely, but anyway, I can't wait for Mr. Minch to tell me. But go ahead, keep going, Mr. Pierce.
The second main objection for all these interrogatories is that we've served too many. We've served 16 in this case. There's never been a previous objection that we served discrete subparts. We're allowed 20 under the court rules, and I don't understand how we've served too many in this, and so that's just another unfounded objection. The 4 interrogatories have also been the 3 interrogatories rather have also been objected to on relevance and proportionality. So the first one, RFA number or interrogatory number 14, asked for only the facts and circumstances of 8 requests for admission. Those 8 requests for admission are all the same subject matter. That is about 8 invoices. They asked the RFA is, did you object to them or did you not object to them? They said that they objected to them. Okay, give me the facts and circumstances around that. Number 15 is about this assignment document. We talked about this last week. I just want to know the facts and circumstances around it. When was it signed? What was the consideration? How was it signed, et cetera? They say that information is privileged. Not sure how that information could be privileged to the extent that there's consideration, when, who, why. That's not privileged information. And so that needs to be answered. Number 16 is about a 3rd line. The line that my client built was the 2nd line. There was supposed to be a 3rd one. I want to know what happened. I want to see if they failed to mitigate their damages. So that's what our 3rd one's going to. All those objections should be overruled and they should be made to answer that. As far as the request for productions go, there's 2 at issue here. I've tied everything together to the request for production in my motion. I can go through it more in detail if you'd like. But basically, there's 6 buckets of things that I need. The first bucket is
I'm sure the other 30 attorneys here are going to love you to go in detail.
I won't. I'm not going to.
Please, while you guys have a discovery tit for tat. I mean, come on, guys. This is.
I understand.
It's all.
There's communications. I want communications regarding that assignment document. If they're privileged, please produce a privilege log. We produced privilege logs previously. The next one is communications with third parties. They say that third parties had to come in and fix the line. They produced vague invoices and check. I would like those communications. The third one is a primary Excel sheet. They gave us a table with manual inputs for cycle times. It's the crux of their case. They say that comes from another Excel sheet that has all the data in it. I want the data. The fourth one, there's EDI messages.
Okay. Just let up. You know what I usually, my usual policy. I thought you guys had a couple of motions to compel wait for last. You guys just aren't playing nice in the sandbox. I'm going to deal with all these other folks and get them rolling. You two can wait while you bill your clients $500 an hour. I don't care, but I'll deal with it. I'll go line by line and painstakingly by painstakingly. But if we're going to come every week with motion to compel, your clients are going to pay a discovery mediator to deal with this because there just isn't the bandwidth every week to have you two here on this interrogatory, that interrogatory, this request to produce, go off camera, pick up the phone, narrow these issues, and I'll deal with you dead last because I have to discourage coming every single week. And there better be a darn good reason for the timeliness argument because that could be sanctionable because if it's served during discovery, it's timely. The other stuff, maybe there's something to it. I'll wait to hear from Mr. Minch. Roll a call the next case. Okay, we're back at it. Let's recall A123 and 5 Synetics and all that business.
5 Synetic Corp. versus A123 Systems LLC, case number 24005-524 CB.
Okay, Mr. Minch, Mr. Pierce, welcome back. Abigail, Ms. Schaefer, you're welcome as well. You guys are lucky I got a short docket today. Otherwise, you would have been in the
That's right.
you would have been in the doghouse a little bit longer here. So let's get down to it, guys. Okay, so I've got timely issues, proportionality, relevance, privilege, too many. Mr. Pierce, were you done with your presentation or did I cut you off? And
I mean, I had a couple more things to get to. Just, I'm happy to finish, or if you want to ask questions.
make your record.
All right, thank you.
I'm glad you're happy, Mr. Pierce. I'm not.
I'm not. I'll make my record, Your Honor. So I was going through the request for productions. I think the last thing I asked for was a primary Excel sheet giving me the cycle times, which goes to the heart of A123's counterclaim. They admitted that they copied and pasted that. What they given me from a different Excel sheet. I would like the primary source with the data. I would also like EDI messages between JLR and A123 going to part of their damages claims that they had to pay for premium shipments. Their corporate rep admitted in a deposition that such communications exist. All I have are invoices in check relating to these transactions. I want to see the underlying communications. Next, they claim, and just two more. Next, they claim that they have over $2 million in salaries that we owe them. And to prove that, they produce a screenshot of a general ledger, this general ledger, and I put a bunch of numbers in there. Those are the general ledger numbers. All that general ledger says is direct labor and then a number. I don't know if that's for all the labor in the company, if that's for all labor related to the line that my clients built. There's other lines at this factory, so I want to see the underlying data. Or I'm also happy to just take a full general ledger. He can redact it all he wants, but I just want to make sure that this is the salaries for the stuff he's claiming. And then finally, I'm requesting wire receipts, ACH transfers, anything showing which entity paid this. As we discussed, I have evidence to show that a different entity paid for the line. They're asking for a refund as part of their damages claims. You can't get a refund if you didn't pay for it, so it's relevant. One final note about timing, and then I'm done. They said at the beginning of their motion that Thieves has no one to blame but themselves. Your Honor, we asked for damages information in September. We did not get it until 5 months later. We asked for an interrogatory in September. 5 months later, constant meet and confers. And it wasn't until the eve of mediation that we finally got $6.5 million damages based on 10 discrete categories. I previously asked for more time. I asked for discovery until July. This court, you split the baby. You gave me until May. And we've been rushing to get this discovery done as quickly as we can on $6.5 million of discrete damages. And this is probably it. I can't imagine there's another motion. Me and Mr. Minch, we were almost close to being able to figure this out. We didn't, so we need you to call the balls and strikes.
Okay,
that's all I got.
Just real quickly here. This case just turned about a year old in April. Status conference in July. I can't remember. Are you guys queued up for a facilitation or case avail or what's
we mediated maybe 2 or 3 months ago.
In February.
Oh, okay, all right, and didn't obviously you
No,
didn't get
unfortunately. Nope.
So this isn't relevant to today, but what's going to happen? I mean, are we just scheduling trial or what's the?
Yeah, I mean it's a bench trial, Your Honor. The parties would have to stipulate to have you conduct a settlement conference, and I'm happy to talk about that with you and Mr. Pierce. But
yeah. Who facilitated? If you remember.
I do. It's on the tip of my tongue.
Don't
you
don't
know
tell
him well.
Is it Judge Rosen?
No, it was hold on. I feel awful.
Yeah, me too.
Must have been
it was
must
Tom
not have been
McNeil.
It was Tom McNeil. Tom McNeil.
I was at his state bar performance the day or two before. Yeah, Tom McNeil.
Yeah.
Well, he did a fantastic job, but this is obviously very contested, and it's 6 years old. So
you guys might have to go to the closer here. Jerry Rosen's closed a bunch of these auto cases for me. So
yeah, Jerry Rosen's great. It wasn't anything that Tom did. It's
no, Tom's great too. But I don't know. Either go back to Tom or Rosen close.
Yeah, you're on. I think Thieves has already filed summary disposition motion. I think there's one I will file by the end of the month, another one fees will file, and you get the joy of hearing and ruling on those, and deciding if the case has to have a bench trial scheduled or not. So
okay, well, we will deal with all that at the July 22nd. I just was curious, but Mr. Minch, your response.
Yeah, I mean, there's a lot here. I can start broad and we can go narrow as much as you want. You know, as to this timeliness issue, it was one argument. It's not the definitive argument, but under the 2020 amended rules, Your Honor, discovery has to be served such that responses are due before the completion date, meaning they would have had to been due by May 29th, not on the May 30 completion date. So, you know, for that reading in the plain language of the court rule, they're untimely. The court rules also state unless there's leave of the court or reasonable circumstances, discovery motions aren't to occur after the close of discovery because there needs to be finality here. So I think the last two discovery motions, which have been after the close of discovery, are also ultimately untimely, but it's up to your discretion whether you want to hear them, Your Honor. As to the interrogatories, I've cited federal law. It's very well known. You can't say, here's 100 requests for admissions. As to every single one you denied, give me a very detailed explanation. It puts you over the limit, Your Honor. The second interrogatory as to this assignment issue, we already have a deposition happening in the next 2 weeks. Most of it's privileged anyways. It wouldn't be worth anybody's time for me to put together a big privilege log with the dates in which I corresponded with my clients about the assignment in this case. As to the last interrogatory, as to this other assembly line, it has absolutely nothing to do with this case. It is not related to thieves. My client has dozens of these assembly lines throughout the world that makes batteries. I candidly have no idea why Mr. Pierce is even asking about it, but that's clearly irrelevant. So happy to start with the interrogatories, or if you want to have me go through the request for productions, I can do that as well.
Go ahead.
As to the third set of requests for productions, the first one, again, relates to the assignment. I'm not going to produce copies of my emails with my clients. And if all he cares about is the date that this was signed, he can ask the corporate designee about it in 2 weeks. And the next request for production, as well as probably 5 other, if you read the motion, Your Honor, all relate to this production evidence, which my client testified about 2 weeks ago in full support of our damages. I talked to Mr. Pierce yesterday. I told him it was all produced. I went on my computer. I pulled up the Bates numbers. I showed him all the Excels of all the production evidence was produced. So I think all of that is moot. As to the request for 5 years worth of emails between my client and any vendor that provided any work to fix this line, I think it's overbroad. I think it's disproportionate. And all the invoices have been disputed. Thieves hasn't disputed that A123 had to pay third parties to come and fix the line when they stopped working on it. So for a $40,000 claim is to parts and a $200,000 claim is to labor, I don't think it's proportionate to go try to find 6 years worth of emails with every single vendor that provided any work on this line. My client testified about all the work 2 weeks ago. We provided all the invoices and we provided bank receipts to show all of the payments were made. As to these EDI or correspondence with my client's customers, Jaguar, Land Rover, it's not a disputed issue in the case. I provided Your Honor testimony and emails from Thieves CEO that because this line was defective, because this line was slow, my client had to pay for essentially taxi companies to take these batteries from the Czech Republic and drive them to Germany and the UK all on an expedited basis because the line wasn't operating at cycle time. Mr. Pierce won't deny that the line wasn't operating at cycle time. So we gave a chart of all those shipments, including the shipment locations. We gave invoices for every single shipment, and we gave proof of payment for every single shipment. If it's some thought or fishing expedition or conspiracy that my client was just paying to expedite these products for some other reason, and I'm not sure what to tell Mr. Pierce, but we've given more than enough. And the very last set of requests, Your Honor, there's this obsession by thieves about who paid for the line, and it's not disputed. A123 Systems LLC paid for the vast majority of the contract. The line was shipped to the Czech Republic. A lot of change orders were issued because the line had to be changed because it was not working. Those change orders were issued by a related entity, A123 Systems SRO, which is an Ostrava entity, and that Ostrava entity paid for these. Thieves has proof of all of that. They can go into their general ledger, they can go into their bank statements and see, who did this wire come from? I don't think it's proportional for my client to have to go and look through their bank records to give something Thieves already has access to. And it's not a disputed issue, Your Honor. So I think that covers the majority of the, I'd like to say, narrowed requests in this motion, but I don't want to lose sight of the fact that if you go and read all of the discovery requests, they're vastly overbroad, which is the reason we started this process, because there was no specificity. And it wasn't until I got this motion that I said, well, I only want this production evidence. Okay, brother counsel, we gave it to you. So for all these reasons, I think discovery needs to come to an end. We've been here 3 weeks in a row. We've put people up for depositions. There's been hundreds of thousands of dollars spent on attorney fees. And we have another deposition coming up, and we should be focusing on filing our dispositive motions by the end of the month, Your Honor.
Maybe you guys should be focused on resolving the case.
Well, that too.
Perhaps the lawyers are in the way, but that wouldn't be the first time around here.
I can assure you it's not me and Mr. Pierce that are the issue. We've worked very well together.
You guys are the foot soldiers. I get it, Mr. Minch. All right, Mr. Pierce, a reply, sir?
Yes. So for the interrogatories, we did not ask for an interrogatory for 100 RFAs. We asked for interrogatories based on RFAs 8 dealing with the same exact subject matter. So that's just not true. For number 15, despite the fact that we're having a deposition about that assignment document, we're still entitled to have an interrogatory answered about it. As far as number 16, the third line that was produced, this was a line that my client at the time was bidding for, and I think another company got it, but it goes right to the heart of our defense that they failed to mitigate their damages. I'm entitled to know the information about it. As far as the RFPs, so the communications related to the assignment, if there's communications between Mr. Minch and his clients, of course, it's privileged. But if there's any other communications, it seems like it's a business deal that happened here. If there's communications between the companies that aren't privileged, I'm entitled to see those, because that assignment document, despite Mr. Minch asserting that it's not a key document in the case, it is a key document in the case. As far as the production evidence, it's true. We do have a lot of that production evidence now after we met and conferred yesterday. But the Excel spreadsheet with the cycle time data, we still need that. As far as the communications with third parties, I'm not asking for 5 years. I just want the communications directly related to those invoices that they sent me. Same for the EDI messages. Mr. Minch never mentioned those general ledger accounts with the salaries in his counter argument. I think if he's going to claim that we owe them $2 million of damages based on salaries, I want to know what those salaries, what those workers were doing. And I want to know the basis for that. And then the 6 for the refund, it is disputed which company paid for this line. There's evidence saying that A123 LLC paid it. There's evidence saying the Czech company paid for it. So to be able to go into your bank records and see which company paid for it shouldn't be that too onerous of a task. So for those reasons, we ask you grant the motion.
All right, the court's had an opportunity to review the motion, the response. There's been oral argument here, and the court does conclude, find, and hold that the requests were timely, that and the court rejects any proportionality, relevance, privilege objections. The court has reviewed Exhibit E and attached to Mr. Pierce's motion here, and does believe it is in order, and will entertain that order, which should address those issues, and the primary source Excel sheet, the EDI messages with the caveat, the general ledger, and the items related to the wire and ACH, which is relevant as it relates to which entities made the payments in question. I believe I've covered the bases, gentlemen. One party certainly believe so. I want to make sure everybody's on board that I've covered the requests that have been made of the court today.
I just want to, make sure I understand it. So taking exhibit, I believe it was maybe it was exhibit E. I have exhibit D as the proposed order.
I've
So
got E, but let me make sure.
Oh,
You're
bad.
right. You're right. No, it is D.
okay,
Yeah, it was labeled as exhibit E, I think, in the body, but it is exhibit D here.
my bad.
No worries. I have it in front of me. Okay, go ahead.
So we're going to grant the motion. So kind of as it's written here, including the primary source Excel sheet. I mean, I can take out the stuff about the evidence, the production evidence. I can just include the primary source Excel sheet. I'm not sure if in here those communications, I guess there's the privilege bit at the end to produce a privilege log. I just want to make sure we're good with that.
Yeah, that goes without saying,
Okay.
Anything non-privileged, privileged log.
And then the only other thing is, I don't know if it's explicitly stated, I just want to make sure if there are non-privileged communications related to that assignment document, that those would be produced.
Fair game.
Okay. That's all I got.
All right, gentlemen, I assume you'll finesse any modifications to this, get it for my signature and
Your Honor, I just have one, and maybe Jimmy, you can agree on this. In the last part of the proposed order, there is a request for pay stubs, salary memos, and other documents related to the salaries of the people in the Excel spreadsheet. I don't believe under check law I'm allowed to give those type of documentations. And I don't understand.
I'll help you out
Go
here. So
ahead.
we met and conferred about that yesterday. I'm good with what you had previously sent me regarding the pay stubs, but I do need to see the general ledger information.
As to those accounts listed. Okay.
As to those accounts listed, but I'm good. I don't need all your pay stubs. It's fine.
all right,
Okay.
so you guys have conferred on that issue, so we need to delete the pay stubs from sub 3.
Pay stubs, salary memos, and other. Jimmy and I will be able to work this out. Your
Yeah, we
Honor.
can figure it out.
All right, okay.
I appreciate your time, and I
Okay.
can't imagine there's any more discovery motions, but I guess we'll see.
Mr. Pierce, if there is, that's what I'm paid for. Every now and then I grumble about it, but that's my job, so no need to apologize. I give you guys a hard time, but you both have my respect. You're both fine lawyers. So
Thank you.
Well,
thanks
Thank
for
you, Judge.
Thanks for putting up with my grumbling from time to time.
Thanks for putting up with our motions.
The motions to compel are, if I had any hair, man, I'd lose it.
At least we're not fighting about our clients going to a doctor appointment. I mean,
Anyway. All right, guys, I'm going to stand
Thank
in
you,
recess.
Judge.
We'll see you next time.
All right. Thanks, Judge. Take care.
Bye.
See you guys. Bye.